In consequence of aforesaid observations, discussions made, and reasons assigned, having found good cause shown by the appellants, so as to be persuaded to condone the delay in filing writ appeal, the interlocutory application bearing YA number 2585 of 2023 is allowed, subject to cost 25,000 to be deposited with the High Court Bar Association Advocates Welfare Fund, Cuttack within 4 weeks hence. As Sri Swapnil Roy appeared for the opposite party, notice need not be issued. The counsel for the appellants is requested to serve copy of the writ appeal on him. List the writ appeal before the appropriate bench for consideration on merit in the matter.
I agree.
Item number 2, RVWP 161 of 2024.
The interlocutory application bearing IA number 245 of 2024 is dismissed. Consequently, the review petition is also dismissed with cost assessed at 25,000 to be deposited with the High Court Bar Association Advocates Welfare Fund within a period of 4 weeks from date.
Okay.
The submission item number 3.
My lord, the writ appeal was dismissed on 16/2/2023 because I missed the list on that day.
All right.
I filed
Restored.
For orders item number 4.
Wait, please, Your Lordship. On the day this writ application was dismissed, my lord, I have stated on affidavit in the CMAPL, my lord, I was,
It has been listed for removal of defects.
Lord, I'll comply with the
Remove
defects.
the defect.
I'll remove it within a week, my lord. Deep limits. Both matters, my lord, 4 and 5 as well.
Yes.
Within a week, I'll remove. Grateful.
Item number 6.
Right, number 6, my lord, there are defects for not filing certificate. Could you give me
Remove
allowed
the defects.
on this?
Item number 7.
Item 7, may I please, madam? The writ appeal was dismissed, my lord, on the ground that the file was not traceable by the order dated 27/10/2022.
All right. When was your application dismissed?
27/10/2022, granting liberty to file fresh fresh application if the file will be traceable, my lord. There is a delay, my lord. Notice has to go.
How much is the delay? What is
Delay more than a year, my lord.
more than a year?
My lord.
It was dismissed after notice.
No, my lord, because the file was not traceable. That is why this writ appeal was dismissed. Your lordship kindly have a glance to order dated 27/10/2022. The appeal is dismissed for non-prosecution with liberty to the Union of India to revive this appeal once the file is traced or reconstructed. Thereafter, we file the CMAPL, my lord, after obtaining all the certified copies.
Issued.
No notice has been issued.
Mr. Counsel, whether any writ appeal notice was issued to the other side or not.
Writ appeal, my lord. No, my lord, writ appeal notice was not issued.
Writ appeal, eligible for claim number 1 to 5 by the next year. Issue notice on the question of limitation as well as admission to the respondents by registered post PKB.
Issue notice. Yes.
Okay, sir.
If I write an exception because I am filing one application for filing additional documents. That's a reappeal. So seeking leave, I am filing application. I made a prayer to list it sometime next week. Your Lordship, in fact, allowed it to list it next week. But inadvertently in the left hand article shall come item number 1.
Ask someone to be here when
Sir.
it matters.
Adjournment, item 3, I have already taken the consent of the government. Other matters are not taking with it. 2 weeks after, I need them. Item 3.
You're enjoying your interim order?
No,
Yes, you are allowed to give
no,
admission.
and the other matter will not come.
That I know. I was asking about these matters which are listed today.
Yes. 2 weeks after, I need them.
Let the matter be caught. We'll see.
Matters under the heading for orders, item number 6.
Item 6, my lord, I had copy, but had already been filed on 10/12.
Maybe pardon me, Lordship. And for the respondent, Your Lordship, the respondent has died in the meantime, Your Lordship. Let the State Council file the appropriate application for substitution.
When did he die?
I give the details, Your Lordship.
No, after receipt of notice or after your appearance?
Your Lordship, our name has been appeared, Your Lordship. Therefore, notice has not been issued.
Name has appeared without your filing wakalatnama?
No, Your Lordship. In the read petition,
No, in the writ appeal, your name
notice
has
has not
appeared.
been issued.
Your names appear.
Yes, sir.
So have you appeared without wakalatnama?
No, Your Lordship, our name has been appeared because in the read application, we have appearing for the petitioner. That's why our name has been appeared in the read appeal, Your Lordship.
No. You have filed a wakalatnama on behalf of Krishna Chandra Sahu dated 7/11/2023.
Your Lordship, I will
Please
take
check.
instruction. Yes, Your
Please
Lordship.
check. Don't make such submissions.
Yes, sir.
Irresponsible submissions. Yes.
But
Okay.
Your Lordship, I have instruction that the respondent
Yes,
is
when?
no more.
When?
Your Lordship, I will take
Mr.
instruction.
You're Mr. SP Jana?
Abhinav Swai, on behalf of
Abhinas?
Swai.
Mr. Abhinav Swai, learned counsel, appearing on behalf of Mr. SB Jana, learned counsel for the respondent, submits that the respondent has died in the meanwhile. So you'll have to take steps for substitution?
Yeah.
How much time? 2 weeks? Full stop. Mr. Bimbisar Das, learned additional government advocate, submits that certified copy of the impugn order has been filed on 10/12/2024. He prays for 2 weeks' time to take steps for substitution of respondent number 1, of the respondent.
Ma'am.
Yes.
Great privilege.
List the case after 2 weeks. So when will it be? 18.
18/12.
2 weeks comes to next January.
2 weeks comes to next January. Today, what is the date? Yes, you're right. List the case on
8 January.
8 January.
8 January. Item number 7.
7, my lord, certified copy has been filed on 10/12. There has been a delay of 190 days.
How many?
190.
So what is the subject matter?
Counting of past service in job contract establishment for the purpose of
Number of matters. Yesterday also number of
Yes,
matters were there. So have you posted those to next week? Job contract was there yesterday.
16/1/2020.
Okay. Issue notice on the question of condonation. I mean, Mr. Bimbisar Das, learned additional government advocate, submits that the certified copy of the impugn order has already been filed on 10/12/2024. সেটা রিট আপিল লিখবে তারপরে no further orders says further orders that means some order has been passed. Just one moment, please. Okay. IA 2916 of 2023, issue notice on the question of condemnation of delay. The normal order returnable within 4 weeks, list after 6 weeks. So what is the date?
29th January.
Always.
Item number 8.
Allowed certified copy. Here in this case, we have not received a copy of the certified copy. Allotment that may 3-4 days time. Within that period, it will be and delay is 104 days.
Thereafter,
Sorry,
there's some other noting also.
Notice issued to respondent 1 to return with the report. Addressee cannot be located, hence return to sender. Addressee long absent to.
So certified copy of impugn order not filed.
Yes, that's what I was saying. This copy I couldn't receive. You have also made 3-4 days time may be granted. Within that period, it will start.
Office note indicates that notice issued to R1 and R2 has returned unserved with the report addressee cannot be located, hence returned to sender. Please check what is the address you have provided.
Right.
Mr. Bimbisar Das, additional government advocate, plays for 2 weeks' time to obtain the correct address of respondent number 1 and 2 and file the requisites. So whatever else you have to do also, you do it in the meanwhile.
Right.
You check, they may have given the office address, you may have retired in the meanwhile. So maybe that is why it is necessary. This is the case on 8.
8 January.
Yes.
Item number 9.
Did one time file certified when on 4/12 when we have filed applied it we have not received over. And the delay of 256
Mr. KC Kaur, learned additional unlearned government advocate, prays for an adjournment. This is the case on 18/12/2024. Yes.
Item number 10.
10, my lord, there is a noting that defect as far as are not removed. Defect is reported to have been removed on 6/12.
This
File
is the case on 18/12/2024 as prayed for. Sorry, Mr. Bimbisar Das, learned additional government advocate, submits that the defects pointed out by the stamp reporter has been removed. This is the case on 18/12/2024. Office registry is directed to verify and verify if defects have been removed in the meanwhile. Yes.
Item 11.
11, my lord, certified copy has been filed on 10/12.
Defect number 9 is a certified copy or something else?
I'll have to see that.
Date check.
Mr. Bimbisar Das, learned additional government advocate, submits that the certified copy has been filed on 10/12/2024. This is the case on 18/12/2024. Defect number 9 shall be removed in the meanwhile.
Ma'am.
Item 12.
For certified copy 1 week, there is a delay about 422 days.
1 week has already been granted for certified copy.
My lord, we have applied 4/7 within 2-3 days we are getting, but now it is
This is the
delayed.
case on 6/1/2025 as prayed for. Yes.
Item
So
10.
when did you apply for the certified copy?
On 4/12 we have applied and
And you have not received.
not received.
You made the online application.
And online.
18/12.
8 months.
Yesterday, I was submitting to your lordship several applications were filed. 85% cases we have got certified copy. Some cases there were some difficulties. You have talked to them, they are saying that within 2-3 days it will be.
The difficulty, we want to know what is the difficulty. Why are they not giving?
They have not expressed the difficulty, but they have short time 2-3 days. Within that period, they can give. That's why.
Yes.
Item number 13.
So 12, 18/12. Okay.
Item number 13, certified copies was applied on portal for PM.
This is the case on 18/12/2024. Prayed for. Yes.
Item 14.
The certified copy not received.
14.
Yes, my lord.
So it will come next week. This is on 18/12/2024 as prayed.
Batch matter which had gone on 15th January.
15.
Item 14.
Item 15.
14.
14, 18/12. They are
Item
not,
15.
not filed the certified copy.
Item number 15.
My lord, pursuant to lordship's direction,
we have filed the fresh requisites stating the correct address of the respondent name. On 9/12, we have filed the fresh requisites.
9/12.
9/12.
Madam Jenna has appeared for some parties.
Respondent 8.
She has appeared for
R8.
2,
8,
3,
2,
6,
7,
7, 8, 10, 11, 12, 13, 14. So 9 was left. 9, what is the order? Yes, when did you file?
9/12.
You filed on 9th.
12th. 9th.
Mr. S.B. Ponda, learned additional government advocate, submits that fresh requisites for service of notice have been filed on 9/12/2024. List the case after 6 weeks. In the meanwhile, notice shall, who is R9?
Bapi,
Okay.
Baditya.
In the meanwhile, notice may be issued in the requisites filed on 9/12/2024 are accepted. Notice shall be issued to the respondent number 9, returnable within 4 weeks. Sorry.
It's already issued on 10/12.
Oh, issued. Oh,
It is
sorry.
specific
Thank you.
adjournment.
Thank you. Yes. List since notice, fresh notice has been issued to respondent number 9. List the case, returnable date.
Because it is 11th, 12th, 1 day only.
No, returnable date that will lekha hai through while issuing notice.
Because it is adjourned to today. So if they have only fixed the date on the next day, 11th.
How can they do that? Fixing 11, 12. How can that be? Not using it.
Yes.
Yes, would have been listed, but they would have filed.
4 weeks.
Yes.
15 January.
Yes, list the case on 15/1/2025, awaiting AD.
Item number 16.
16, my lord, certified copy has been filed on 10/12. And the copy of the IA and WA writ appeal have already been served on 10/12.
I received yesterday. I going to file.
Mr. Bimbisar Das, learned additional government advocate, submits that the copy of the impute order has been filed on 10/12/2024, and copy of appeal memo and application for condemnation of delay have also been served on respondent number 1. On the counsel for respondent number 1, Dr. Puttatham Chulli. Full stop. Dr. Chulli, learned counsel, prays for 1 week time. 1 week time to file objection to the application for condemnation of delay. List the case on 18/12/2024.
Item number 17.
17, my lord, there has been a delay of 341 days. This is a case that Niranjan Behra, you also may remember, basing on that judgment rendered by the Honorable Single Judge in Niranjan Behra's case, this case has been allowed. On the plea that SLP was dismissed, the SLP was dismissed without
delay.
Yes, without going to the court.
Niranjan Behra, not Niranjan, Nityananda Biswal.
Nityananda Vishal or Niranjan Behra both have been tagged there.
Now, what is that regarding counting of past period, or what is Nityananda
Yes,
Biswal?
yes. Period of service rendered will be taken into
Number of
consideration for the
matters
purpose of
raised
pension.
yesterday. So, a date fix for you, will
Part of it,
Sorry?
12/1, possibly 12/1 it can be.
No, it has been posted to today because similar matters are there today. So let us pass over and see what are the matters.
Yes.
Okay.
Well,
So pass over here.
item 18.
18 my lord certified copy today at the first hour we have filed. This is the receipt, my lord.
What is this, that job contract?
Um,
Because I remember some matters, similar matters were kept today.
Today, in item 18, my lord, there are 4 matters.
Yes,
All are similar matters. The benefit of regularization,
this is level 5 assistant.
Rule 3 of 1981 rules that is to be.
So in all these cases, impugn order has been filed,
Yes,
all the cases.
yes, ma'am. Certified copy, in one case it has not been filed. That is, your lordship, first case, 2162, certified copy has been filed on 9/12. Second case, my lord.
Sorry, could you please repeat, could you please repeat?
First matter, item 18.
Today. Yes,
Today it has been filed, my lord.
yes,
Sorry, it was filed on 9/12.
first one,
First one, 2162.
okay,
Second matter, 2163, my lord. Here, certified copy has not been filed.
okay.
Third one, certified copy is not the.
Not filed.
Fourth one, 21998, this has been filed today. Certified
Okay.
copy.
This, the writ of, जो item 18, ऊपर कर देगी list these matters on 18 कर दिया सब गुड़ा list these common cost study करी list these matters on 18/12/2024. You please and the ones which you have not filed, please file it.
I'll
Yes, office to verify if certified copies of the impugn orders have been filed.
Ma'am.
Item number 19.
19, my lord, there has been a delay of 59 days. Prayer for regulation in service, he was continuing on DLR. After completion of certain period, he
Issue
has,
notice. 6 weeks. Date? 6 weeks.
29th January. Item 20.
your lordship, 19, your lordship.
19 issue notice.
20 minor, there is delay of 56 days. Regarding cancellation of pass certificate and probability getting employment.
Notice. All right. The same 6 weeks.
Item 21.
They have sought permission for to attend the academic session counseling 23-24.
They have become infectious.
Dida can make a common order. Shall we leave it? Keep it to tomorrow. Your notice appearing for the.
Item 27 and 28 also the same.
You are for whom?
I'm for the university OP6 here.
Who is for the petitioner?
I'm for the OP6.
Understood. Nobody is there.
Petitioner.
Keep it to tomorrow. None appears for the common order. What are they? 21 the data out. 26.
27, 28.
27, 28. None appears for the petitioners when the matter is called. Mr. S.J. Pradhan, learned counsel appearing on behalf of the
Orissa Health University.
check for the Orissa Health University submits that these writ applications have become infructuous. Full stop. Since none appears for the petitioner, since there is no appearance on behalf of the petitioners, list the case tomorrow. Yes.
Item 22.
These cases tomorrow, sorry. Yes.
22.
22, my lord, approximately that means 3 days time for certified copy. 22 and 23, we have not been able to file.
How many days?
3-4 days certified copy.
Yes. Mr. Bimbisar Das, learned additional government advocate, prays for some time to file the certified copy of the, prays for 1 week time to file the certified copy of the impugn order, considering the said submission, the impugn, said submission, 1 week time is, considering the said submission, the 1 week time is allowed for filing the certified copy. The I is accordingly certified copy of the impugn order. The I is accordingly allowed and disposed of. List the case on 18/12/2024. Yes. 22 same.
22 and 23. both.
Yes.
Yes, sorry, 22, 20.
What
Yes.
is matter of? There's submission item number 1.
Yes, you were saying about adjournment.
My senior has mentioned this.
Well,
1 minute.
when do you want? I requested on behalf of the applicant, put this matter on 1 week.
Item number 2.
But the petitioner was pursuing what is Bachelor in Visual Act. And it is being aggrieved with the external profit parties for not allowing him to sit in the exam. And
What happened?
even the petitioner was pursuing his Bachelor in Visual Act. He was admitted, my lord, and the grievance is that is not the authority is not allowing the petitioner and allowing some other students to appear in the examinations.
Right.
And the reasons are not known as they approached because Lordship would see when Mr. 1 the college manor, the open number 3 has issued the admit card. Lordship the Lordship pays 10 and Mr. 1. College is issued admit card. And we have honored the college has also accepted that the required fee deposit which required from the student.
All right, we'll see. Which institution, which university is this? Or
It's called University of Culture, Mala.
So do they have any counsel or you take notice?
Notice.
okay.
Malad, we have just now got the information. Now the examination, they're not allowing in the now.
Nothing can be done without hearing the other side.
No, sir.
Yes. You could have filed your petition earlier.
No, we have not filed. Now, just on 7th, we have got the letter that they have conducted the internal examination, which they are not allowing us.
They have conducted and not allowing this
Like
what? It is over.
No, now the internal examination is started.
What
of
examination?
18 internal examination. No, two examinations. Internal.
Yes.
Internal examination is going to head on 18/12.
So what can be done? Without hearing the other side, since when you are not allowed to, not being allowed to attend classes? Since when the petitioners are not being allowed to attend the classes?
The petitioners are allowed, but they are not allowed to sit in the examinations. And earlier the grievance was that they are not allowed to sit in the semester examination. Now there are the notification now. 7th, 12th, which is by the college itself.
So when was the semester examination held?
Hello?
When was the semester examination held?
Well, 2 semester examinations have already been completed. We are fully.
When was that held? When was the last semester examination held?
That was my lord on 1/8/24, my lord.
So when did you file the writ petition?
So semester examinations you are allowed to sit because of order of this court or
No, I am not allowed.
permitted?
I am not allowed.
Semester is
No, I am not allowed.
Mr. Counsel, you are not allowed to appear in 2 semester examinations. Did you approach the court?
Yes, ma'am.
So what happened?
Approach the court was not this.
When?
I filed writ application.
no, not this writ. Semester examinations are over.
Yes, my lord.
When was the first semester examination held?
It was my lord. First semester, my lord, is that on 24/4/26.
So when did you file the writ petition?
My lord.
This writ
We
petition.
can see.
Only my lord,
You will file it.
allowed in the
August 2024.
Yes, ma'am.
Then, and you are seeking interim order today.
No, the interim order for the internal examination.
What is this?
Now,
Sorry.
No, but if you have
Just
not,
I'm, but last time I'll give you the letter.
no, you give it the letter, it is all right.
What's the kind of thing? Kind of thing.
See, Mr. Counsel, you were not allowed to appear in the first semester examination.
But we are allowed to sit in the internal examination. Now they are not allowed even to sit in the internal examination. That is the
So
only.
what will you do with internal examination if you don't appear in the semester examination? Can you pass? Can you be declared pass with the internal examination results?
That is also we have to pass the internal examination as well as the semester examination.
Semester examination, you did not have any grievance.
We have given, my lord. We have given, man. That is the given one. We have given. So we have
Oh, prayer in the writ petition is to appear in the semester examination, academic session 22 to 26.
It's a frivolous application. Issue notice number.
You want to take notice by special messenger?
Lordship.
2 weeks.
Look at the connected episode, same other petition. That is not in the board manner. Similar matter.
Do we have the jurisdiction to pass an order on a matter which is not listed?
No, I'm not sure.
Item number 3.
Cost to assets by payment tomorrow. It's talking in.
May I please the lordship, the matter relates to admission of ITA fairness. In respect of this, some counter is the record which has not yet been filed.
Have you admitted students? Have you admitted students by virtue of interim order?
No, my lord, we have not done.
Where you given a
From that occasion, I clear for the interim order, but you are not.
maybe only one case. The one case interim order may not have been given.
Interim order is required if 14047 by 2.
Now, other case, that is the writ number 25454 of 2024, and another 19984 and WPC 199224 are not listed, madam, because that is also fix of another today the entangle of other matters and all matters here.
Entangle the
That is
matter.
not listed, madam. So your lordship tag the all the matters. Then that will hear only thing because interim order already in effect, madam. Admission part already over. So 2 weeks time for the other matter will come with
1 year.
Why can't it be tomorrow and why 2 weeks?
The regender we are not filing the regender. Counter not filing.
Nobody is stopping you.
Yeah.
Counter has been filed in this case.
No, a case line. Amo case line.
Counter has been filed in all these cases.
Other case line.
My lord, in
Counter
this
has been filed in all these cases.
my lord, in WPC 26123, count by 2024, counter is not filed, my lord. On last occasion, your lordship has said this matter and
2623 is not listed today.
And what is the last date for admission?
That was something we allowed them to take.
Update already.
No.
already gone.
Already gone, ma'am. Admission cut off date already gone. Extension.
I don't know whether this.
No, we shall decide these matters on merits. High adjournment.
Well, some of the documents is still yet to receive from the petitioner.
Means
Petitioner,
you file the writ petition.
how much time do you, how much time do you?
Exactly, 2 weeks only, man.
No, we will grant you 6 weeks.
No.
The regender will not file, ma'am.
Huh?
I have filed the regender, ma'am.
Don't do
Stop you
it.
from file.
Don't file the joinder.
Some instruction is necessary.
Whether there is any interim order in this case or not.
Yes, madam.
There is an interim order. We are vacating that interim order. And you take 8 weeks time.
Yeah.
So what? So what? Remove them. No, no. No. Your intentions are not clear. No rejoinder. Don't file rejoinder. When was the counter affidavit filed?
August till Lordship, 21st of August.
August. The counter affidavit was filed.
I have received yesterday one counter mailor. That is it, double piece number 25454.
All right. This matters on Monday, Tuesday. So we make it clear that we shall not grant any further adjournment and decide the issue on merits.
Mr. Das, is 25454 listed today?
So that's why I have
No. So we are asking the matters which are listed today.
No, madam.
What no?
Yesterday, I have received this.
Have you received that counter in respect of any of these cases?
No.
Okay.
All right. Come on Tuesday.
Tuesday, madam.
Yes.
My lord, counter is also required in 26123.
Is it
Which
listed?
one?
Is it listed today?
Yes, listed as
Okay.
first case, my lord. 26123 by 2024.
Yes.
Counter is also not filed in this case. So before Tuesday, the counter.
We will see. Counter may not be required.
That counter, they have
We don't know. You can't compel the other side to file counter affidavit. If you have a weak case, that can be dismissed without counter affidavit. If you have some case, then they may be required to file counter
We
affidavit.
have all cases because
We don't know.
allowed admission. We took admission, verifying all details they have allowed me to.
We will see.
The last chance में 2 weeks में.
No. Sorry.
Lord, I beg to appear, Lord, for the petitioner.
What the time rate here?
Lord, I am here. If your Lordship can take it up now, then it will be okay.
Mr. Ratagi, we had picked this case for 12:30.
All right, I'll be here at 12:30.
It is mentioned in the list also.
Lord, if the other side is here, it will not take more than 5 minutes, Lord.
12:30 we will take up, Mr. Ratagi.
All right.
That will be proper.
Let's.
Item 5.
Let the present petitioner file the contempt application due to non-compliance of the order passed by this honorable court, that is Annexure 1, my lord. Annexure 1, order dated 10/7/2024. My lord, may I permitted to read the para 3, my lord. Learned counsel for the petitioner submits that this petitioner and one of his brother were the principal borrowers and their father was guarantor, who had mortgaged his property for repayment of the loan taken from the opposite party number 1 bank. He submits that after sale of the mortgage property, some amount has remained in the hands of the opposite party number 1 bank after appropriation of the loan dues, and that is not being refunded to the petitioner and his other co-sharers, who have inherited the property of late B. Subramanyam Achari, the guarantor. He also submits that on some occasions, all the legal heirs having even gone to the bank premises, they had to return for non-cooperation of the officers of the opposite party bank. The learned counsel for the opposite party bank submits that the opposite party number 1 bank has no intention to cause any harassment to the petitioner and others by not refunding the excess amount. That would be evident from the fact that the amount has been very much kept in the fixed deposit, which is accumulating with interest. He, however, submits that if the petitioner would now be filing an application afresh with the legal heir certificate in the original, the opposite party bank, on receiving the same, would verify all details.
All right, we are issuing notice.
My lord, after their admission, this honorable court directed me to file a representation before the bank.
All right, we are issuing notice.
I have already sought the copy of the other side, but they have not appeared.
Then we can't force them to appear.
My lord,
Issue notice.
may I permit it to take special measure?
Take
Monday.
special message. Yes.
Special messenger and contact.
But why in contempt special messenger is not?
Problem.
For admission, I think 24.
24.
Come up on mentions.
Mr. Panda is an accommodation.
No, we will give you, grant you accommodation. Why did you make a mention? Why did you make a mention for from tomorrow? I'll not entertain even a single mentioning because of this, the conduct of yours in this case. Not even a single mentioning.
Sorry.
All right. How much time?
1 week.
2 weeks. List this matter on 4 weeks ago. 4 weeks. The matter has been listed today on priority basis on a mention having been made on behalf of the petitioner for early hearing. Stop. Today, an adjournment is being sought. So stop. It seems that the petitioner has no urgency and mention was unnecessarily met. So stop. List this matter on 8 weeks. So from tomorrow, I'll not entertain even a single mentioning. This is happening in most of the cases.
25 and 2 PM it was paid.
He doesn't understand anything.
Just a minute. Who is for the other side in this case? You had made a mention.
Item 24.
25.
Who is for the other side?
24. Somebody is there. Find out the behalf of the respondent. Yes. 1 week. We'll come next week.
And requested on behalf of the petitioner.
And it is fixed at 2 PM. Man.
Okay. 2 PM. Yes. Adam?
25, my lord. My lord, item 25 is fixed for 2 PM.
2 PM, this bench may not be available. Is there any?
That course manager.
Yes. Tomorrow at 2.
Not 26.
26 is although matching has infrastructure. Both of them.
What your name, please?
Indira Priyadarshini.
Representation on behalf of the respondent.
25 to 18 of 2023.
Matter has been listed.
22.96 of
On mention having been made on behalf of the respondent, the opposite party. Yes.
Yes, you said something. It has, this also has been listed on mention.
There are two writ applications.
Yes.
Both have become.
So she's mentioning for both, I think.
Yes. Yes. Yes.
Yes, madam.
You are appearing for somebody in item 26.
Item 26, opposite party number 6.
So they are saying it has become infructuous.
Item 26.
Item 26. You have wisdom that. Now you are mentioning.
Yes.
My lord, I am the highest bidder in the tender and I have deposited 5,44,000.
But they are not pressing the writ petition. Withdraw. Dismissed as having become infructuous. seeks permission to withdraw this writ application as the applications have become infructuous. Dismissed as withdrawn, having become infructuous. Entry model is standard. Yes.
Item note 29.
Item 27, I am for the petition. All the matters have become infructuous. Who has action, I don't know.
First matter, second again.
I am for the petition. All the matters have become infructuous.
Yeah.
Item 27. For tomorrow, along with item 21. Petition also not present in item 21.
It is the infructuous product.
I am for the petition 27.
27 infructuous.
I am for the petition.
Yes.
Ma'am,
How about me?
item 21 is called simultaneously.
Okay.
Similar level.
Infructuous services. Yes.
28.
I am Mr. Asimati.
All right. Give you
Open up forum.
yes.
Item 28.
28, your lordship, the counter has not been filed. With the
That is also infructuous.
Yes, ma'am.
Infructuous.
Infructuous. It is for the academic season 23-24.
Whether it has become infructuous, madam.
No idea about.
All right, tomorrow.
What is your name?
Meenakshi Jain.
Meenakshi
Jaina.
Jena. On behalf of item 28.
Item 29.
In item 29, I am for the opposite party, bank. Yesterday only I have entered appearance. Yesterday I have entered appearance. I received the notice yesterday and I immediately can I a week after.
Are you respondent 3?
I am all respondent 1 and 3 are same.
Okay, no, because the noting said it is not back, so then all right.
That may be made sufficient.
All right.
Mr.
E.V.
Balakrishnan.
P.V. Balakrishnan has entered appearance on behalf of opposite parties. Respondents number 1 and 3.
1, 2 and 3, all the
1,
respondents.
2 and 3. First off, he seeks adjournment. So does this matter on 1 week?
A week after. Let it be first week of January.
First week of January?
Item 30.
There is a problem, Mr. Balakrishna. You filed Vakalatnama only for OP 1 and 2.
1 and 2. 1 and 3 are same.
Okay.
1 and 3 are same.
This is the bank and it is the chairman, so I have to make the party guard.
Okay. So has appeared for all the
Respondents. Can be treated as all the respondents.
Yes.
Item number 30.
The petitions are filed by the clerks of the district of Puri, who are made partner, confirmed, but without any proceeding, without following the 311 and without proceeding rules.
What has happened?
I have filed counter.
My lord, by order dated 4/7/24, there is direction to produce the record. That is not. I take 1 week time to produce the record.
It will take, I don't know. I have this case 8199, which I have keep 3 posts reserved for us. I will only say it will have the result.
Counter in the main.
Let the recruitment have the result of this case. Because the dismissal itself is bad on the face of it. Dismissal from service without proceeding, confirmed employee.
What was the issue? What is the issue? I have not been able to understand.
My lord, employees of the district judge were recruited.
Employee of the district judge recruited.
District judge court. Staff were recruited, clerks recruited. They are confirmed in the meantime. But subsequently, the district judge, by a 50 order, without receiving the proceeding, without so called anything, dismissal from a side. So I have filed it. So they are going to face recruitment in the meantime. So therefore I have filed a miscase to
to keep 3 posts reserved for us. I will satisfy if my lord says, let the recruit be subject regarding.
Sorry. Why it has been listed before division name? Service.
Or the appeal committee of the court. We have filed appeal, that has been rejected, we filed it.
No, it has come here.
Judicial staff.
Oh, why division not?
No, I only pray, my lord.
No, we are only asking that why it has to come up before a division bench.
Against the appeal committee decision of this honorable court, this it has been filed. Judicial employee.
Let us see the impugn order. Let us see your appointment first.
Next 8 C.
8.
68.
This is Jagat Singhpur.
Jagat
Singhpur is so this is your appointment letter. And where is the termination?
Termination. Yes, I think it was 141. It's 141, and it's 16.
141. This is your appointment letter. Oh, sorry, termination. 141 is something else.
Show replies, 141. Annex 16, 142, common termination order. Page 142. Confidential letter.
But it says that you were illegally.
This is because there are recruitment original recruitment, number of posts.
What?
There are recruiter for engagement number of posts.
What?
There are recruiter for some posts.
Some posts.
These persons were in the facilities. That is valid for 1 year.
No, but for some posts, so these persons were not employed. Those posts were filled up. You were because
of the administrative excellence of this, because new posts are open, by they appointed us from the
Where were you living when you're where were you living when you were appointed? You were living at Cuttack when you were appointed for Jagat Singhpur.
No, that is not the issue, because there is no
issue we understand, Mr. Counsel. So whether the district judge had come to your place to tell you that you are very meritorious and you should come and join the.
Yes, madam. All that happened. What happened?
No Chief Justice has gone to your place. Only the district judge.
He is the recruiting officer.
Dismissed.
Madam?
Dismissed.
Madam?
Yes, next.
Item 31.
Read the dismissal.
Yes, sir.
Can I get a reading out of this?
Yes, you will surely get.
No, I say, we were selected, we got appointed.
We understand your selection, we understand.
We became confirmed in ultimately.
Right.
Ultimately, but if you confirmed employee.
All right.
You are relevant to that to proceeding.
All right. Yes.
31.
In 31, in spite of your lordship, several chances given, the government has not filed counter in respect to Annexure 6. Huge government land which has been given for industrial purpose to the opposite party number 10 to 13.
Now they are trying to alienate the same to the private person, and they stop their work there. And after the industry department directed the collector Cutter to inquire into the matter in 2020, Annexure 6, page 73, the collector has inquired into the matter and given a report. There is his report, page 73, and finally on 77, he has concluded saying
Yes,
that
have you filed your affidavit?
they have not filed in spite of 4.
Have you filed? Why are you not filing affidavit? Madam, you are appearing for the last date. This is 15880 2024. Ramesh Chandra Nayak and others.
That your lordship, today we are filing, on the last occasion, I had said, I had taken the report that we were filing out on the very day, but your lordship, on that day, there was some discrepancy in the records. So I called for the collector and the records, your lordship. Pursuant to my intimation, intra-departmental meeting has taken place under the chairmanship of the chief secretary, and they have forwarded the file to the law department for opinion, your lordship. And
File
today
this
we have
not
filed the
affidavit.
affidavit. Your lordship, I've just signed it. It must have been e-filed by now, your lordship.
It has been done, Mr. Bali.
Today, your lordship.
And time and
Okay,
again,
I'll serve the copy.
your lordship, may I say one thing?
And your lordship, the collector has written to the Tahsildar also not to mutate the land till the government takes a final decision.
That may be recorded, your lordship.
Yes,
That
that has
Record
also been
after
annexed in
affidavit is
the-
filed.
that
They
has
are-
also been annexed in the.
But they are not filing the affidavit since 4 and
Today,
5
Mr.
times.
Barley, they are saying that they filed today, you get a copy. Is the associate here in court?
That is their version since last 4 chances, and
Mr.
they are
Bahali.
saying like this.
I don't think
May I
the
take your lordship's
government
permission?
counsel will make a false submission before this court. You can ask for
If
time.
If
Today
they are
you said it has
goes
been
on
filed
time
today.
time
All
and
right,
again,
all
they
right.
go on. You
All
lordship,
right.
they record their statement. They record their
We
statement.
will do what
You
you want.
dictate the order, Mr. Bali.
No, I cannot dictate. I can.
With your lordship's permission. With your lordship's permission, I appear for OP 10 to 13. May I just, your lordship's take your lordship's 1 minute.
No, let the affidavit be filed. Why
Very
not?
good, very good.
Ms. Suman Patnaik, learned additional government by advocate, states that in the light of this court's order dated 4/12/2024, the counter affidavit is going to be filed today. First off, let copies of this counter affidavit be served upon learned counsel for the petitioner and learned counsel appearing on behalf of opposite parties number 10 to 13. 10 to 13 in course of the day, you can do it.
Yes, your lordship. In the course of the-
Stop this matter. 1 week. Time in the-
Your lordship, may 2 weeks after filing, I will file my rejoinder.
4 weeks.
Item 32.
Yes. 4 weeks.
32. Item number 32.
Where is Mr. Naik? Has it become infructuous? Very strange. Mr. Naik is not around. 32. No, you're doing this, but file is with whom?
Yes.
You're the state counsel, so you should inform us.
No,
When
ma'am.
I'm asking whether the matter is infructuous or not, you're doing this.
No, my lord, not infructuous, but they have filed amendment petition, but they have to serve a consolidated petition on us to which we should have replied by additional affidavit. They have not served that. Consolidated.
In 412, you had prayed for time to file affidavit.
But consolidated has not been filed. I have filed the counter affidavit in the meantime.
To file additional affidavit.
But that additional affidavit, that is not the, my lord, actually, that is the counter affidavit. Counter affidavit I have filed in the meantime, my lord, and served copy on 12/11.
When did you file?
My lord,
On 412, you had asked for time to file an additional affidavit. So it can be additional counter affidavit also.
I have not been served with a consolidated petition.
Then you asked for time, we didn't ask for service of copy.
Consolidated, I have not filed, copy has not been served.
There is a direction. 13/11/2000.
Copy not been served.
13/11, when he asked for time, that same copy has not been served. But I think of course, they don't do it. Amendment petition, that whatever extra is there in the amendment petition, it's subject.
So it appears that this court's order dated 13/11/2024 requiring the petitioner to file a consolidated petition. Yes, right? Yes, consolidated petition has been filed.
Yes.
Consolidated he has to file because
He has filed it.
Yes, he has filed it,
but
copy has not been served. Yes, filed it.
There is no representation on behalf of the petitioner. Let's this matter on 2 weeks. Yes.
Item 33.
The copy will be served.
I am submitting a copy of Mr. Mahanti to take a decision. Unless until the DND take a decision, for a relaxation or exemption, neither the state, nobody can refund the any penalty. So DND is the final authority in terms of the guideline. The last time page 48. It is clear.
Yes, you serve a copy.
I will serve a copy in course of the time and take instruction any next.
Let a copy of the patent application which served upon then counsel who represents DMET.
OP number 2, DMET.
DMET bracketed OP number 2. Top. Let's this matter on 4 weeks. So as to enable and counsel for the DMET to seek instructions and file affidavit if so advised.
Yeah, Mr. Casey Swine. I want.
Item number 34.
We received the counter on 7th, 12th manner. We want some final decision that pray for 2 weeks time.
Yes. Yes.
Yes. Counter we have filed for OP number 6 and 7. They are seeking time for rejoinder.
And counsel for the petitioner seeks adjournment. Consider the counter affidavit which has been filed on behalf of the opposite parties. To file rejoinder to the counter affidavit filed on behalf of the opposite parties. As requested, let's this matter on
2 weeks.
2 weeks.
Union of India has not yet filed counter. Union of India is also a necessary party.
We will see. Yes.
Which matter is that? Item 35.
Yesterday, we have received an additional counter affidavit. I request some time. It's short date.
They have made yesterday. I will spend out.
Counsel appearing on behalf of the petitioner seeks adjournment to file rejoinder to the counter file.
Instructions. Additional counter. Rejoinder may not be necessary.
Seeks adjournment to consider the additional affidavit filed on behalf of
The opposite party number 1.
Space 1. This is on 1 week.
1 week.
1 week. 1 week. Stop. You want?
My lord, in IA number 16,
740, my lord. They have filed yesterday, my lord. I have received the copy and filed my objection after, my lord.
London Council for, you are for which party?
OP1, my lord.
Only one or 1 and 2?
I have appeared for 1 and 2, but given reply only for 1.
London Council appearing on behalf of OP opposite parties is number 1 and 2. Seeks leave to file objection to the interlocutory application.
My lord, I number 167.
He shall be at liberty to do so. He shall be at liberty to do so. Yes.
On the past
In the meanwhile.
matter passed over item number 17.
Well, item number 4.
It's on date.
Acha.
Well, would your lordship take up item 4?
It's for delay. Item 17. Item 17.
Similar matters will issue notice, but similar matters. All right. If I recuse it within 1 week.
Item number 4, take it up at 12:30, otherwise
12:30 we will take.
My lord, we are here. My lord, is it okay with your lordship, my lord? Mr. Rohtak is here, my lord.
Can we take up?
Yes, yes.
All right.
Yes, Lord, it's a very short matter.
Yes.
Lord, actually, your lordships have dealt with a near identical case a few days ago and granted an interim order, but I must show you what that case is and what my case is. Lord, kindly turn to page 138.
Yes.
Item number 4.
138. Lord, I am a mining company operating, Lord, in the state of Odisha. Now, Lord, there is an allegation against me at page 138 that I have violated a lease condition and have removed certain stacks, my lord, of mineral. If your lordship turns to 138, my lord.
Just a minute. Which annexure is this?
This is, my lord, annexure 2.
Yes.
This is 29th August 24, my lord. It is addressed to us. We are JSW. Show cause notice for violation. With reference to so-and-so, I am to say, please mark, my lord, as per joint inspection report conducted by SLES team in respect of your iron ore block, the following observations are made. That, my lord, there is some problem with the stock, etc. Now, I asked them to supply me a copy of the joint inspection report. My lord, I have asked for it, my lord, by several letters, but it is not given to me. For example, see 141, my lord.
Yes.
My lord, I have said, my lord, that you have not given me third line. As indicated, a joint inspection report was conducted. A copy of the report along with details of checks are not included, as a result of which we are unable to understand the observations, etc., etc. Because we are saying, my lord, we have committed no wrong. We are a big company. We are not into clandestine removals. Now, my lord, your lordship sees the thing is perpetuated. Violation of natural justice perpetuated at 142. I get another show cause notice, my lord. Now, this is dated 19th of November. This says subject show cause with reference to the above. As per joint inspection report, my lord, has not given. As per so-and-so, in respect of so-and-so, reported that there are 84 stacks, but in so-and-so, balance stacks are so-and-so, it should be so-and-so, so-and-so, so-and-so. Now, my lord, middle of the paragraph. Basing on the said report of SLES, a committee was formed with the mining officer on so-and-so. Committee has gone through the report of SLES and verified as below. Now, committee report is not also given to me. So, my lord, so you build a pyramid. First, you have an SLS report not given to me. Then you build a pyramid, my lord, that you have a committee report which has examined, my lord, the SLSC report. That committee report has come to this finding. My lord, I asked for this also. This is also not given.
145.
At 145.
Starts at 144.
At 144, at 145, my lord. I at annexure number 5, at the foot of that page again said we requested your good office by these letters of 4-9 and 11-9 to give it, but you haven't given it. Now you're talking, my lord, of some committee, and then we say at the last paragraph at 145 that please give us the report of SLES and the report of the committee. Now, my lord, nothing is done. Nothing is done, my lord, and then a hearing is fixed, my lord, at 146.
Annexure 6.
At Annexure 6. I, my lord, go and give a reply at 147, which is, my lord, a preliminary reply at the same day. I was asked on 27th November, I give on 27th November. Now, my lord, an order is passed. If your lordship will see, my lord, the order is passed at page 189. Annexure number 9. Of the same day. So, my lord, see how it is done. You don't give copies of any report. You call me for a hearing, I go give a reply, and on the same day. So this man is working overtime, my lord, on the same day. Everything happens on 27th November. And your lordship will find at 190. 190, my lord. The second recital in the middle of the page. Whereas you have attended personal hearing, submitted a reply which is not satisfactory. That's it. And you have now imposed, my lord, a penalty on me of some 100 and something crores. That, my lord, is the case. Now, your lordship may have a look at, my lord, a similar order passed in the case of another minor. It appears, my lord, that this is some kind of a concerted effort going on at the state's end. My lord, if they will, my lord, my junior will pass on the order. Kindly pass it on, please, to the court. Kindly pass it on to the Honorable Chief Justice. And, my lord, a ladyship, my lord, kindly have a look at this one. Sorry, give another copy for her ladyship, please. This is not the way.
So why is this happening in each and every case?
So here also, my lord, same report of same SLES. My lord sees the paragraph 3 towards the bottom of that page. A report on base of SLES, despite request, report not made available, etc., etc. And then, my lord, same thing. In my case, it is worse, my lord. There's another report of committee also not given, and same day everything is being done.
Oh, why? Why?
I don't.
This is happening in each and every case, Mr.
Every case they are doing it.
You are deciding something. You are fixing liability on the basis of a report, and the person does not have any access to such a report.
I'll file a counter explaining that. Whether I have to check whether it was supplied or not, and
have you filed a counter in WPC 26785 of 2024? Same thing.
It did not file. It was
Just recollect 26785 of 2024 code date.
no, counter not.
Then, we are just cautioning you that we will pass a general order. Why in each and every case we have to, and this is most fundamental, that if you are relying on a document for taking a decision against a person, then that person should have the liberty to have access to such report.
I'll communicate your lordship, sir. You.
212.
It is not reached on that date. It is not listed.
We'll tag it with that method.
Similar order. Similar order.
Similar.
Yes, my lord, similar order.
Yes.
Very grateful, my lord, for your lordship's indulgence.
And revision you have not filed because of those orders in those similar methods. Mr. Parija?
Yes, my lord.
Revision you have not filed because of those orders in the similar
Yes,
methods that
because they have now said that if it is in the OMPTS Act, then there is no revision.
Yes. So shall we tag it with your matter?
Yes, my lords.
Because I remember there was
Yes,
one.
Mr. Venugopal will give the number to the court master, my lords.
Yes.
Grateful. It's better your lordship tag this with our matter. Yes. We will give the number, my lords.
That matter is coming back.
First week of January. First, second week of January.
My lord, your lordships have it on the second week of January, my lords.
Yes,
second
January. Yes, second week.
Yes.
Yes. That's why the week got
My lord, grateful, my lords.
Yes, my lord. As page 41, clause 36, my lord.
Yes, so notice.
Item number 2.
Lordship, in this matter, Your Lordship, item number
2.
Arbitration number 92. Yes. Lordships, here in this matter, I'm appearing here of the petitioner. There's a dispute arising out of the service agreement between the parties. And Your Lordship, we kindly have a look at page number 38 of the service agreement between the parties, where there's an arbitration.
Which annexure?
Annexure number 4, Your Lordship.
Annexure 4.
Here, please, page number 38. Also, this was a subsequent agreement entered into the between the parties. In regards to the initial agreement, which was entered into the parties, 27/8/2022. A second agreement was entered on 14th of January this year.
Oh, where is the arbitration clause?
Your Lordship's page number 38, Your Lordship. Matter 6, Your Lordship.
Yes. So,
Item number 3.
Page 65, members. Page 65.
yes.
23F, AF, page 65, subparagraph.
Which clause? Page 65.
It's page 65. 4 months. 25.3.
Issue notice.
It's this is for us to examine. I'd like to Lordship to glance at page 126. The same matter, Manus had directed that orders one counsel appearing on behalf of the petitioner after some argument seeks permission to withdraw this petition for appointment of an arbitrator under section 11(6) was a liberty to make a fresh petition. This is the fresh petition, Manus. The petition, what has happened? Similar two matters, Manus had already appointed the arbitrator. The only thing because I had not sent an advocate notice.
Understand.
Otherwise, same.
Or is you are receiving accepted notice?
I accept the notice.
All right.
What I read from a last fellows, arbitrator, senior advocate, Mr. Mona Mishra has been appointed in other two matters, similar, 22 and 23 of 23. So, minus why would I claim us because this content is the same. Why not the.
They will have to be given an opportunity.
And there, the principal employer is also state theirs for management, not the state managers. Because I have not sent a advocate notice to state, managers are directed to give a notice, then come on. The principal employer, I got
2 weeks. Issue notice, to accept notice. Does this matter on 2 weeks?
Orders item number 4.
I'm entering.
For withdrawal.
My name may just be noted. The respondent number 1.
And I'm for respondent number 2.
Item number 5.
This item number 5, my lords. We have issued fresh notice. The fresh notice has been delivered, but the AD has not returned. So let's give just 2 weeks time may be granted. Let's check if the AD returns delivered, then we can proceed as ex parte.
Does this matter on 2 weeks waiting service of notice upon the opposite party? Yes.
Item number 6.
Much obliged.
Item number 6, we have filed in IA. Let's remember about the 1 judge and 3 judges issue. That issue we have requested for along with Justice C.R. Das, another judge may be inserted for 3 judges.
Yes, I remember. I just missed to.
6 and 7 both are the same issue, my lord.
On Monday it will come.
Yes, ma'am. Yes, ma'am. Yes. Yes.
Hello, on Monday for orders.
Monday for orders. Tuesday. Monday I am not here.
Yes, yes. Any day. Yes.
Obliged. Obliged.
Wednesday, Mr. Khanna, I just.
No worries, obliged.
18th. 6 and 7. Item number 8.
Item 8, OP number 1 and 2 are the same persons, my lord. Nobody has appeared. They, an arbitrator can be appointed. But your lordships. It's a money claim around 30 lakhs money from the dealer.
Where is the arbitration clause?
Page 22, my lord. Para 19.
Page 22.
Yes, para 19. Any dispute or difference? Should I read it, my lord?
Yes.
Any dispute or difference of any nature, any claim, cross claim, counter claim, or set off against the of the company against the licensee with regard to any right, liability, or omission on or account of any parties arising out of in relation to this agreement shall be referred to the sole arbitrator. That is the director, but now since the law has been changed, I leave it to your lordship.
This application has been filed for appointment of an arbitrator under section 11(6) of the Arbitration and Conciliation Act. So, despite valid service of notice, the opposite party has not entered appearance. So, after having gone through the details on record, I find that there is an arbitration clause in the which clause you said?
19.
That clause 19 of the agreement in question. Provides that any dispute or difference in any nature shall be resolved through the process of arbitration. So, accordingly, what is the amount?
Around 26 lakhs, 28 lakhs around approximately.
Dr. Justice A.K. Mishra. A.K. Mishra.
Item 9.
On behalf of Mr. Amita Pradhan, I almost pay for only 1 week time.
As requested 1 week. Yes.
Item 10.
In 10, as per the order passed by my lord, that is order dated 2011-2024. The reply has not yet been supplied.
The reply has been filed today, my lord. We will have to copy the-
When AC, Assistant Standing Counsel representing the opposite party has submitted that a reply has been filed today.
Today, my lord.
Today. Copy has been served.
No copy has not been.
Copy of which shall be served on one counsel for the petitioner in the course of the day. To place this matter on 2 weeks.
Item 11.
Okay.
Mr. Mahandi's present. Mr. Mahandi's present and allowed for seek and consent.
As requested on behalf of the opposite party, place this matter on 1 week.
Vacation minutes as.
Post holidays.
Item 12.
The petitioner, as a replacement was filed. And the petitioner, the reply has not been filed by the opposite party.
The reply has been filed.
Not filed. Not filed.
They can suggest a name for the arbitrator. If they want, I can also suggest a name for the arbitrator for the appointment of arbitrator. The popular senior advocate, popular authority, and then also the advocate for the arbitrator. If they don't have any objection.
You are for the petitioner. He is suggesting a name. If you agree, it's all right. And you are also independent to suggest a name. All right. So if the name is different, then the court will appoint an arbitrator, any person.
Next week.
Why next week? Give me the list.
Item 16.
12. Arbitration 87 of 2023.
That's it. I can go now.
After Sanjeet Mohanty.
I think what should do.
Item 13.
May it please this honorable court. The application for appointment of arbitrator. The arbitration clause is at page 24.
Two orders are there previously.
Who is appearing?
Similar matter. Two orders are there for appointment by arbitrator.
Well, it's the same clause between the opposite party.
Who is the arbitrator?
Justice Pramad Patnaik.
Pramad Patnaik.
We are agreeable.
Whether he has any difficulty because of his present assignment?
We can take consent, my lord.
No, he is chairman
of OD8 matter.
Whether he can accept or whether he can do arbitration.
No, arbitrator.
No, he has already concluded those arbitration.
No,
Facts
yes,
are all the
concluded.
same conspectus. That's why
Some other person should be appointed. We don't know whether he should accept or not, whether he can do it or not. So let us see.
Only one changes. This is order can be passed.
it's the same order.
BP Das? Or Mr. BP Das? Same order shall be recorded.
Yes, ma'am.
Order which has
Only that is the counterclaim there. Counterclaim I have taken a stand that updated versus to pass an order that keeping my right to file counterclaim. That is statutory right. Still then let's see Russia has passed that order, so that I want that order should be there. Blind.
Item number 14.
In decision 11.6 application to Lordship, the agreement is the clause is that point number.
Who is on the other side?
I'm the lost. Point number 15 at the see the last 28 number. It goes to report that this is a clear copyright dispute. And dispute is infringement. So it is non-arguable. And it submitted a judgment of the Supreme Court 2021 to SCC page 1, which we have gone through the judgment. The Lordship this judgment only. I'm only taking to your Lordships to para number 244.2 and 3. In the last page of the judgment.
Page?
Page number, it is on my compilation, it is 162, your Lordship.
Oh no, which paragraph?
244.2 and 3.
244 paragraph of the judgment.
Yes, your Lord.
Page 152.
162, 163 page. May I give you?
Just let me see whether. Honorable Justice Ramana's order. Paragraph?
244.2 your Lordship. 2 and 3 are relevant.
44?
Yes, your Lordship.
Paragraph up to 75 is there. Page or paragraph? Page is 241. You are referring to which?
Vidya Drolia judgment.
I think Vidya.
Yes, sir.
Okay, just. Internal page?
Internal page, your Lordship, 163.
Yes. Yes.
My Lord. Here, my Lord, after taking into consideration all the, my Lord, grounds and all the decisions.
163 is paragraph 17. No.
My Lord.
Paragraph 7 at page 163.
Yes, sir.
Paragraph 17 is there before we move to the analysis. You are
reading the SCC.
Oh, you are having the SCC.
Yes, that is why, because that is a continuous paragraph. This is it has been breaken up in this judgment, original judgment. Okay.
Do you have the?
Yes,
okay.
yes, one extra.
Yes.
5 page just last of the compilation.
Black mark.
All right.
My.
Yes.
Point numbers 244.2, your Lordship.
Yes.
Well, usually the subject matter of arbitrability cannot be decided at the stage of section 8 or 11 of the Act unless it is clear case of de do. Thereafter, the court under section 8 and 11 has to refer the matter to arbitration or to appoint an arbitrator as the case may be, unless a party has established a prima facie summary findings case of non-existence of a valid arbitration agreement by summarily portraying a strong case that he is entitled to such finding. Then till the next
244.5. The scope of the court to examine prima facie validity of an arbitration agreement includes only whether the arbitration agreement was in writing, whether the arbitration agreement was contained in exchange of letters, telecommunications, and whether the core contractual ingredients for the arbitration agreement were fulfilled. Here, my lord, as we have demonstrated, there was an agreement clause, and one party is saying that there is the subject matter of the dispute is arbitrability, so far as the my lord, copyright is concerned. Though we have on the last occasion, we have specifically stated it's not at all a case of any question of my lord, copyright. It is purely a dispute between the parties who are natural brothers, having inherited the property from their ancestor. My lord, one property, the dispute between the brothers have been taken place, which is within the scope of the arbitration agreement executed between the parties. So all these aspects can be well determined by the arbitral tribunal, my lord. So that is my whole submission.
Yes. The minority judgment. What he read is the minority view. Lordship takes up page 149 of the uploaded judgments.
So you will have to cite from one common thing, either from the SCC or.
Because I have given the judgment which is downloaded from the Supreme Court website.
So this is minority view of.
The minority view.
By?
Justice Ramanna.
Ramanna is not minority. It's not minority
last
view.
page. Last page. In that, they may not be there, but in the uploaded judgment, which is downloaded, that is only Justice Ramanna is the signatory.
So what? Because the judgment has been written by a particular judge, therefore that becomes minority view.
No, the three-judge bench held, two judge held that no, it is the arbitrability. This copyright is not an arbitrable dispute, and section specifically they kindly see page 21 of the judgment I have given, which has been uploaded para 18.
Yes.
Writing. Subsection 3 of section 2 of the Arbitration Act states, this part shall not affect any other law for the time being in force by virtue of which certain disputes may not be submitted to arbitration. But this Arbitration Act itself recognizes that some dispute can be non-arbitrable.
No, but how do you say that this is?
Yes, kindly come to Mallard's page 35. Specifically, they say that copyright infringement is a non-arbitrable dispute.
No.
Page 35.
How do you say that that is the only dispute?
That is a dispute. That is the notice. The Lordship takes up, I take your Lordship to the notices where they say that I have infringed the copyright. That is the basic dispute. So, my Lord, page 35, Bruce Allen refers to the statement by Mustil and Boyd and the subordinate rights in personal derived from rights in rem can be ruled upon by the arbitrators, which is opposite. Therefore, a claim for infringement of copyright against a particular person is arbitrable, though in some manner the arbitrator would examine the right to copyright a right in rem. Arbitration by necessary implication excludes actions in rem. So, my lord, my humble submission before your lordship is, since it's an action in rem and the dispute or the claim by the petitioners is that I have infringed their copyright. That is the basic notice and the notice invoking the arbitration. So there cannot be an arbitration. They have to file a suit, which is the remedy which is available in the Copyright Act, section 55 and section 62. Copyright Act specifically says that 55 is the remedy.
Not at any point of time.
Yes, sir. Yes, you are referring to which section? 50?
Copyright, madam. Page, section 55. Civil remedies for infringement of copyright. A specific right has been incorporated.
Just a minute.
Once. May I please?
Okay. Where is the finding of the Supreme Court? Where is the observation made by the Supreme Court?
Page 36. Part of page para 30. Therefore, a claim for infringement of copyright against a particular person is arbitrable, though in some manner the arbitrator would examine the right to copyright, a right in re. Arbitration by necessary implication excludes actions in re. And read with that section 55.
Just a minute. Section, you are reading which paragraph?
Page 35, para 30, part starts from page 33. Thereafter, my lords, I rely on this page 35. It starts at the penultimate line, Booz Allen and Hamilton. Refers to the statement by Mustill and Boyd and the subordinate rights in personal. Derived from rights in real can be ruled upon by the arbitrator, which is opposite. Therefore, a claim for infringement of copyright against a particular person is arbitrable, though in some manner the arbitrator would examine the right to copyright. A right in real. Arbitration by necessary implication excludes actions in real. Another submission is that...
Just a minute, just a minute. Where does the judgment hold that this copyright is non-arbitrable?
That parameter, since it's a, may I place that again?
Yes.
Therefore, a claim for infringement of copyright against a particular person is arbitrable, though in some manner the arbitrator.
It says arbitrable.
No, I'm coming to that. The arbitrator will examine the right to copyright. Only to that extent. Right
what the arbitrator will decide. Yes. Counsel appearing on behalf of the opposite party has relied on Supreme Court's decision in case of Vidya Durulia and others versus Durga Trading Corporation, reported in 2021, volume 2, SCC, page 1. This application has been filed. He has submitted that it is apparent from the notice issued by the petitioner to the opposite party for appointment of an arbitrator that the dispute relates to copyright infringement. Such dispute, he submits, is not arbitrable in view of the Supreme Court's decision in case of Vidya Durulia. He has heavily relied on the observation made in paragraph 30, in paragraph 30 of the said decision. The paragraph 30 of the decision in case of Vidya Durulia reads thus. In my view, the submission advanced on behalf of the opposite party is wholly misconceived. I do not find any at any place in the judgment of Supreme Court in so and so, wherein it has been held that a dispute relating to copyright infringement is non-arbitrable. Stop. Then yes, any suggestion? Name? I will appoint. All right. Take care of this.
Leave may be given to raise that issue.
That is open to you. That is the law. That
But engineering comes in where that once it is leave is so that's moving a section.
That is under the
That leave may be done.
leave is there, Mr. Counsel. You have the arbitrator has the authority to decide every dispute.
One line.
Why? Yes.
Item 15.
It's pursuant to last order of counter has been filed today, my lords. I'll serve a copy to the petitioner.
Yes. Let a copy of the counter affidavit be served on counsel for the petitioner in course of the day. Let's this matter on. Next.
Item 16.
Are you opposing in your counter affidavit?
Yes, my lords.
We have received instructions this morning for Sir, we have received instructions. My lords may give some time.
Yes, as requested. Mr. So-and-so has entered appearance on behalf of the opposite party. He requests adjournment. So talk list this matter on next week. Next week?
Plus 2 weeks.
2 weeks after the holiday has come. Yes.
Item 17.
I appear for the opposite party, my lords.
This is a TP of 2024.
Yes.
Not of me. Yes, what is there in the order?
Last order, the opposite party took time to file a counter. The same has not been served upon me or.
Yeah.
My lords, kindly grant me 2 weeks more, my lords, because my lords, the party is out based out of Kolkata, my lords. So it is getting delayed, my lords. Only 2 weeks time, my lords, because I am challenging the maintainability of this
Notice
petition.
Reply to the advocate's notice. All the grounds of resistance that has been taken up, the same can be decided.
My lords, anyway, I cannot resist, my lords, but as I am only
As requested by
into the
Saswat Raut and counsel representing the opposite party, a list this matter on 2 weeks.
Yes, my lords, 2 weeks.
For him to file the counter affidavit. You have filed or you are filing?
I will be filing, my lords.
Yes.
My humble request to Lordship, no further adjournment will be sought.
It is made clear that,
yes,
that no further adjournment shall be granted in this matter. Yes.
Much obliged.
Item 18.
My lord, item number 18. I'm on behalf of Mr. Mishra, my lord, Soumya Mishra. My lord, we have received the wakalatnama. We'll be filing the wakalatnama as well as the counter within a week, my lord.
I'm appearing for the petitioner for Mr.
You have received wakalatnama and you will file wakalatnama after a week.
My lord, within this week, my lord. Today we have received the wakalatnama. So,
yes.
And the counter is also ready, my lord. We'll file it within a week.
So is for the petitioner.
Well, I'm for the petitioner, my lords. I'm appearing on behalf of Mr. Patri, my lords.
As requested on behalf of the opposite party, lift this matter on 1 week.
Well, after 1 week.
We wait for minutes.
Item 19.
The petition in this matter.
Yes.
Your Lordship, so last occasion I have sought for time for some instruction. The client is ready for arbitration.
Yes. Good. What is the dispute? What is the dispute?
The petitioner has.
No, what is the?
Petitioner has placed an order of 1,15,50,000 for some iron ore and fines, and that's due to the non-payment of the same. They have sent us a notice invoking the arbitration clause.
Because neither there was a reply to the notice minutes, and neither there has been a reply to the section 21 minutes. Therefore, we seek the honorable court to pass on this in this.
SC Parijan?
Yes,
Your Lordships, I suggest someone else other than. Recommend the name of Honorable Justice C.R.
Item number 20.
Yes, Lordship.
20, sir.
Sought for appointment of an arbitrator. Last time took time.
My lord, last time the Lordship was issued and a notice was given to us for instruction. I have not received the instruction. Lordship, give me another 2 weeks time to.
Transportation.
This particular officer is transferred from this place.
Officer has nothing to do.
Only sir, I will take instruction. Lordship, will have 2 weeks after. Lordship may keep it. The second occasion it will
By
listed.
way of last indulgence, 2 weeks for the time is allowed for the opposite parties to file counter affidavit. Yes.
Item number 21.
From 21 and appearing on behalf of the petitioner minutes. Means we're filing the rejoinder documents. Because it's a single rejoinder which is to consider for all these matters.
So are they disputing?
Yes, Your Lordship.
Yes,
I'm disputing.
Why?
That there is not a, if there is no valid arbitration agreement because the transaction relates to the construction of
Yeah. Which item? 41. That's it. Why was that happening?
petitioner is a builder and the opposite party has purchased a commercial unit from the builder. And there is a dispute relating to payment of maintenance dues. So this entire matter is covered under the RERA Act, Real Estate Regulation Act, which provides a statutory format of the agreement. And that agreement provides that the authority created under that act, it will only resolve all the disputes. But
so there is no arbitration clause.
So there is no valid arbitration clause, but going contrary to the provisions of the act, they have inserted a clause relating to arbitration in the present agreement, which we contend that it is not a valid arbitration clause and it is contrary to the statute even. And the statute doesn't give them the permission to change the format provided under the statute. And the registration certificate provided to them under the statute, that also mandates that you will execute an agreement as per the format provided under the statute. And that statute clearly mandates that the authority created under the statute will only adjudicate all the disputes.
Yes. So have you served the copy?
Yes, sir, serve the copy.
Just now.
So next week we will take up. Let him see the rejoinder. That is the only question.
Yes.
If arbitration clause has been introduced, That is contrary to the statutory provisions.
No, Millards. Millards, the arbitration clause existed prior to commencement of the RERA Act, Millards.
Oh.
So, Millards, there's obviously a bar, Millards, in the Act because the agreement of sale was executed in the year 2015, Millards. To safeguard.
It has been, there are two sets of cases. In one set, the agreement has been executed on 27/3/2018. The RERA Act came into force on 1st of May 2017. And they have taken that I've also annexed.
So at least such agreements which are executed prior to coming into force of RERA. So there the arbitration clause is valid.
Even there also, the Act says that anything done contrary to the provisions of the Act when this Act came into force, the rights of the buyers will be safeguarded under this Act. So the rights provided under this
Where
Act.
is that provision?
My lord, that is provided in the rules. Your Lordship, Rule 8 of the ORERA Rules 2017.
No, the rights may be safeguarded, but if there is an arbitration agreement and if party wants to will that.
Act does not inherently bar the resolution of disputes under the arbitration clause, Millards, when they are already existing prior to the commencement of the RERA Act.
My lord, if I may kindly show your lordship, Annexure A to the ORERA Rules 2017. ORERA Rules 2017.
Yes.
My lord, it is at the last Annexure A. The format of the agreement for sale. Annexure A. It is written C Rule 8.1 Agreement for sale.
Yes, that is, you are correct there.
Lordship,
but this agreement was entered into before.
No, in some sets before, in some sets after.
So though in such cases where the agreement was executed prior to this coming into force of these rules.
For that, I will place Rule 8 of this ORERA rules.
So Rule 8.
Rule 8, Sub-Rule 2. I will read Sub-Rule 1 also. For the purpose of subsection 2 of section 13 of the Act, the agreement for sale shall be in the form as per Annexure A. Second, any application letter, allotment letter, or any other document signed by the allottee in respect of the apartment, plot, or building prior to the execution and registration of the agreement for sale for such apartment, plot, or building as the case may be, shall not be construed to limit the rights and interest of the allottee under the agreement for sale or under the Act or the rules or the regulations made thereunder. So, my lord, this rules clearly provides that any dispute will be
No, it provides otherwise. Please read it again.
Yes, Lord. Any application letter, allotment letter, or any other document signed by the allottee in respect of the apartment, plot, or building prior to the execution and registration of the agreement for sale for such apartment, plot, or building as the case may be, shall not be construed to limit the rights and interest of the allottee under the agreement for sale or under the Act or rules or regulations made thereunder. This agreement for sale means this one, the format which is provided here. And if I may just submit, after the Act came into force, a builder has to enter into an agreement and register that agreement with the sub-registrar. And only then he can accept the money. Which has not been done in the
You are reading it just the
which have already been executed prior to the RERA Act.
no, it says please purpose of Rule 2 Sub-Rule 2 of Rule 8 is entirely different. It says any application letter, allotment letter, or any other document signed by the allottee in respect of the allotment, plot, or building prior to execution and registration. It does not say execution and registration of the agreement. It deals with the application letter, allotment letter prior to execution and registration of the agreement for sale.
Yes.
So those documents shall not be constituted to limit rights and interests. It doesn't say about it. This sub-rule does not refer to the agreement. Rather, it refers to the documents prior to execution of agreement.
Yes, or,
Am I clear?
or any other document signed by the allottee.
No, or any other, not or any other. Documents prior to execution of the agreement.
Yes, yes.
Like there might have, some letter might have been issued, some application. So based on that application, his rights cannot be limited. So this is what sub-rule 2
Prior to the
says.
execution and registration of the agreement for sale.
Prior to.
Yes. So
Yes.
here the agreement has not been registered, Your Lordship. The cases which my learned friend is citing here, the agreement has not been registered. That is the question. Only it has been signed. It has to be mandatorily registered.
Arbitration agreement is required to be registered.
The agreement for sale that contains that clause.
Agreement you are saying there, no, it has not been registered. It has not been executed. The agreement has not been executed.
As per this format, after the act came into force.
How this format can apply to registration of a document prior to coming into force of these rules?
Exactly, I'm saying after this act came into force, they have to execute a fresh
That
agreement.
is different.
Yes.
So there can be two classes. One where the agreements were executed post coming into force these rules. So their cases may be different. And the agreement in that case will be a statutory in terms of that. But before that, how can you deny? How many cases have you classified?
I have found out. Because, my lord, these are ongoing projects. These have not been completed. So, I have annexed the certificate also in my counter. They have taken a registration.
Completion is not required. Registration of sale is not required. If there is an agreement between you are the builder.
No, they are the builder.
You are the builder. If there is an agreement, then that can be resolved.
My lord, the very purpose of creating these specialized tribunals, they are 3-member tribunals who are specialized in these fields only, who are from various fields like retired IAS officer, retired district judge, and a retired officer from the public field. So they have.
I'll see.
So I have.
First of all, give me the cases. Give me such cases where the agreements were executed. Agreement does not mean agreement for sale. Agreement means.
That is the only agreement.
You and the.
That is the only agreement available. Agreement for sale.
Right.
That contains.
Agreement for sale.
Yes.
So in that agreement.
Not objection to the published deed which they have executed.
Not?
Because it was not an objection when both the parties signed the sublease deed in the year 2020 minutes.
I'll see the consequence of enactment of this.
If all the cases can be decided before one forum, that could have been better.
No, that we will be guided by law.
Yes.
So if the law permits, of course, one forum will decide. If law does not, if they have after certain rights, that
then it can be segregated.
As a rejoinder affidavit to the counter affidavit filed on behalf of the opposite party is going to be filed tomorrow. You do it tomorrow in the registry. Yes.
The rejoinder.
So rejoinder, yes. Rejoinder affidavit. So list this case on next Wednesday.
Item number 22.
Lord, item number 22, my lord, may I pay for what it's time, my lord, Mr. Roy will be assisting your lordship. Mr. Roy will be assisting your lordship in this matter, my lord. He is suffering from a bad flu, my lord.
Yes.
I'm appearing for the opposite parties number 1, 2, and 3. Opposite party number 4 is actually the election officer in the present case.
Opposite party number?
Opposite party number 4 was the election officer of the society. So
we will see next week as requested on behalf of the petitioner list this matter on. Petitioner on the ground of indisposition of Mr. Ranjit Rayal and counsel list this matter on. 1 week, yes.
Item 23.
Item 23 also.
Same. Yes.
Item 24.
Your Lordship, item 24, I am for the petitioner, Your Lordship. I kindly grant me 2 weeks time to file rejoinder. To file rejoinder.
Hold on, the other side.
I'm to the
As
appeal.
requested on behalf of the petitioner. 2 weeks time is allowed to file rejoinder to the counter affidavit. What is this case? 2 weeks.
25.
Petitioner. I don't know, 25, 26 and 27. In this case, I am for the opposite party. So Lordship allowed me to file counter. I further for time to file.
4 weeks.
Why?
I have no objection, madam. Whether here the appointment is to be decided. Only the appointment of the arbiter.
4 weeks is too much. 2 weeks. Because otherwise it will come after holidays. 4 weeks there. As requested on behalf of the opposite party, list this matter on 4 weeks.
Item number 28.
So as to enable him to file counter affidavit.
May I pay my no further action?
No further action.
Adjournment.
Adjournment. क्या लिखें? As requested by Mr. So and so and counsel appearing on behalf of the opposite party, list this matter on so as to enable him to file counter affidavit. Yes.
Item number 28.
If you can appeal for the petitioner, the railway is the party here, the opposite party, we are supposed to file counter.
Yes. What is for the other side?
Mr. Mrs. Kashyap now name shows petitioner, sir.
Yes, Mr. Kashyap.
Yes, my lord. In this case also, we are seeking time, my lord, because we are not receiving any instruction. Let me give you another 2 weeks. Once it was listed, it's second time, my lord.
Yes.
After 2 weeks after vacation, any day, let's see.
By way of last indulgence, the matter is adjourned to. Yes.
Specialist item number 1. BLAPL 4547 of 2024.
My lord, here, my lord will take this matter along with item 4, because court is bail application there before me. There, my lord have called for a report from the learned second assistant session judge Ramkala why there is an inordinate delay in trust. Case of 307. My lord is directed to complete the trial within a period of 6 months. In item 4, the report has come back.
And you are in custody since when?
My lord, 9/1/2024.
And what is the allegation?
Allegation, my lord, when the complainant was taking his meal in a hotel, so the present petitioner along with others came and assaulted him.
And what is the injury?
Injury, it is always grievous, my lord.
All the injuries are grievous.
Grievous.
How many injuries?
Injury report. Injury.
6 injuries, 5 injuries, my lord.
Caused by?
Caused by sharp cutting weapon, lord. Knife, cutlery, by sword, over forehead, chin, back.
Antecedent?
Hello?
Antecedent.
Antecedent, he is having
this person is having
three antecedent, not of similar nature.
Sorry. Both of them.
And so the second accused, I don't know. My lord, I am not at counsel.
You are not?
Item number 4, I am not his counsel.
So who is appearing in item number 4?
No.
My lord, I am appearing in item number 4, my lord. I am on VC, my lord.
So you have antecedent. The grievous, these allegations are serious.
My lord, in my application, kindly have a glance over page 27, my lord.
Yes.
The assault was by Gopi Singh and Shankar Sharma.
Huh?
The assault was by Gopi Singh and Shankar Sharma, not by the present petitioner, my lord.
What was filed?
My lord, page 27.
Assault. He is stating that assault is by one Gopi Singh and Santosh Sharma, and not by this present petitions.
My lord, page 27 of my application, my lord. That is part of the charge sheet, my lord, final form. It is specifically mentioned that all of a sudden accused Gopi Singh and Shankar Sharma assaulted the victim Bitu Tanti brutally by means of bhujali and sword with an intention to kill him from life. Due to assault, the victim sustained multiple grievous bleeding injuries on his head.
Where are you reading?
My lord.
Where are you reading?
My lord, page 27, second para, 10th line from the bottom.
So you are reading order of the land district judge.
No, my lord, that is the part of the charge sheet, my lord, final form.
Achha, part of the charge sheet.
My lord.
Yes.
My lord, statement recorded under section 161. I am reading, my lord. Specific allegation is that, my lord.
Maybe.
Along with these persons, he is having to add two antecedents.
Maybe. Yes, Vikram, this application has been filed for so and so. And counsel appearing on behalf of the item number 4. And counsel appearing on behalf of the petitioner has submitted that in this case, a charge sheet has been submitted against. Charge sheet has not been submitted against you.
Yes.
No, my lord, charge sheet has already been submitted, my lord.
What is there against you?
Whole allegation, my lord. This his client and my client, they are only accompanying. But the assault part is made by these two persons.
Yes, my lord. Assault is by other person.
The charge sheet has been that in the charge sheet which has been submitted against the accused persons, including the petitioner, there is no specific allegation of assault made by him. Stop. The allegation, the specific, according to the police, the evidence of assault is against co-accused Gopi Sharma and
Gopi Singh, my lord. Gopi Singh.
And
Shankar Sharma.
Shankar Sharma. Stop. He has submitted that the petitioner is in custody since
9/1/2024.
9/1/2024. Stop. By an order dated 23/10/2024, a report was called for from the Court of London Additional Sessions Judge Rourkela as regards the present stage of the trial. Stop. A report has been received from which it appears that not a single witness has been examined so far. despite so far. Stop. Learned counsel appearing on behalf of, learned AG appearing on behalf of the estate opposing prayer for bail has submitted that the petitioner has criminal antecedent. What is the antecedent?
Two antecedents.
Like?
My lord. Nature of offense is not mentioned.
What is the antecedent?
My lord, antecedent is two antecedents, my lord.
What is that?
Under section 379, not of similar nature, my lord.
Or give us.
379, my lord.
Yes.
Under section 37,
Both the
verified.
cases.
One is under section 379, and another is minor offense under section 3 of OPG. Not of a very serious nature, minor.
Criminal antecedent. Stop. Next, however, considering the circumstance that the police, upon completion of investigation, have not found any material of any material indicating assault made by this petitioner, and the fact that he has remained in custody since 9/1/2024, a case is made out for his release on bail. So this is also because there is no progress at the trial. So this application is accordingly allowed. Same in order number 1. Same in order number in item number 1.
Both the cases and same.
Same order for them. Yes.
But 4 disposed of?
Yes.
Okay.
Item number 2.
Meritless. Earlier, bail application of the petitioner was rejected by your lordship, madam. I had order dated 26/4/2024.
Where is that?
During the course of the investigation, madam.
Where is that order?
And
You have not annexed the order. You have not annexed. No, that cannot be done.
that I am submitting. Now the charge sheet has been submitted. There is clear violation of section 50 of the NDPS Act, which vitiates that I am submitting. Kindly for a moment. The prosecution case is itself, my lord. There are 5 persons who are waiting in a bus stop set.
Mr. Counsel, I cannot review my order. All right, you can.
At that time, my humbly submission for lordship, but at that time the investigation was on. In the meantime, the investigating officer complied all the requirements under the act relating to search and seizure. Now, my lord, there is I have let my senior man probably case there is a clear violation of section 50, which may not clearly vitiates the search.
All right. So, if in the, while considering your bail application,
section 50 can be taken into consideration, I will produce, my lord, some citation of this honorable court.
I record a finding that section 50 was violated. Then what will happen?
If my lord, section 50 will be violated, the search conducted from the petitioner, that is illegal, my lord.
Mr. Counsel, therefore, if I record in my order that there has been violation of the provision under section 50, then what will happen thereafter?
It will, my lord, it is entitled to the accused to be acquittal in appeal in the trial, my lord.
So therefore, there would be no requirement of any trial.
The trial is required, but my humbly submission.
Trial is required.
Yes, ma'am.
So therefore, you want that in a bail on your application for bail, I should acquit you. Because the trial court will not differ from the finding which I record here.
Now, this is clearly apparent from the record itself, prosecution case itself. Only I frame it.
The petitioner.
One prayer
The petitioner's prayer for bail was earlier rejected by an order dated 26/4/2024, passed in APL number 2888 of 2024. From the petitioner's possession.
That my humble submission.
According to the prosecution's case, from the petitioner's possession, 22 kg of ganja was recovered. So, keeping in mind the embargo under Section 37 of the NDPS Act, the petitioner's prayer for bail was rejected by an order dated 26/4/2024, passed in Swans. His prayer for bail was earlier rejected. So, by making this application, the petitioner has renewed his prayer for bail. So, counsel appearing on behalf of the petitioner has submitted that when the order of this court was passed on 26/4/2024, charge sheet was not submitted by the police. Now, since charge sheet has been submitted, the situation has changed, and now the petitioner's prayer for his release on bail should be reconsidered. So he submits that it is evident that there has been no compliance of the statutory requirement under Section 50 of the NDPS Act. So next, I am not inclined to reconsider the petitioner's prayer for bail at this stage. You have remained in custody since when?
9/3/2024.
And any antecedent?
No antecedent.
The petitioner has remained in custody, is in custody since 9/3/2024. So, I am not inclined to reconsider his prayer for bail at this stage. So, bail at this stage, keeping in mind the statutory embargo under Section 37 of the NDPS Act. So, it is expected that the trial court, that the trial is expedited.
I'm withdrawing my bail.
Counsel appearing on behalf of the petitioner after some argument seeks permission to withdraw this application. This application is dismissed as withdrawn.
Simply withdraw.
Yes.
Item number 3.
May I please, Lordship? I am appearing through VC, my Lord. Lord, this is a case which is similar to item number 1 and item number 4. Just I realized that it is similar to the PS case.
Same PS case or something else?
Same PS case. Same PS
and
case.
You are not Gopi Sharma and.
I am not Gopi Sharma. I am Tolpo. My Lord, if your Lordship will come to page number 10 of my petition, my Lord.
Just a minute. You are not Gopi Sharma, and what is the other person? Gopi Singh and Santosh Sharma.
Shankar Sharma.
Gopi Singh, Shankar Sharma, and Hanuman.
And
Hanuman Singh.
My name is Dalpo, my Lord.
All right.
Dalpo Saurabh Das.
All right.
And he is not having anti-statement.
Oh.
Arrested on 4/5/2022.
Granted.
Item number 5.
Item number 5, Ms. Mishra couldn't appear due to personal difficulties.
As requested on behalf of the petitioner, does this matter on next Wednesday?
Item number 6.
May I file my Lord,
Fine. Hearing.
My lord, we take a hearing next.
Item 6.
6. Here, my lord, the revision preferred by 4 persons.
My lord, in this case, my lord, senior may sought a copy of the deposition. My lord,
Give him.
My lord, I will. By tomorrow, I will give my lord, let it come Friday, my lord, it can be disposed of, my lord. 7 years conviction, 2 in the meantime died. I will give the deposition, my lord, with me, my lord, but just now, my lord, I cannot solve, my lord, I will solve tomorrow. Lordship, it will let it come Friday, my lord.
As requested on behalf of the, list this matter on next week. Let a copy of the revision application be served on learned AGA in course of the day.
Item number 7. Item 7.
in this matter, my lord, we will collect the copy, soft copy. Because the copy of the appeal memo deposition is not sought to us.
Yes. You can appear. You can appear in this case as a maker. Matter on, and no one appears on behalf of the petitioner. List this matter on 1 week, 2 weeks, couple. What is your name?
Arun Kumar Acharya.
Arun Kumar?
Arun Kumar Acharya.
On the court's request, Mr. Arun Kumar Acharya has agreed to appear as an amicus curiae. So, let a copy of the revision application be handed over to Mr. Acharya by tomorrow. One week. Next week.
Item number 8.
Mr. Divyajyoti Shahu was appointed amicus in the next case. There is no representation on behalf of the applicant. Petitioner, Mr. Divyajyoti Sahu, counsel was appointed as an arbitrator. So he is also not present. Mr. Acharya. Yes, next week.
Item 9.
You will see the order number 7 here. That was passed on 17/11/2021, the last part. Last part.
No one appears on behalf of the petitioner. So same here. 2 weeks.
Item 10.
Teacher estimates from 10 minus have got instruction today to appear. In fact, I filed the power 2 weeks time. I pay.
So states that he has instructions to appear in this case on behalf of the petitioner. He seeks adjournment. Is this matter on? Weeks.
Item 11.
Because it is so similar that in 2001 he was 51. At the time of filing the appeal in 2001, he was aged at 51 years.
In fact, we have requested the government also to supply to us whether the prisoners are alive or not. Getting anything. There is no representation on behalf of the petitioner. Yes, Mr. Acharya, you do. We will also do the formality.
Item 12.
As requested on behalf of the petitioner, list this matter on 1 week. 1 week. One week.
Item 13.
Madam, this matter, in fact, the other day, it was before your lordship. Lordship wanted me to check up whether he was in custody. I was just checking up, subject to confirmation from my side. 4-5 days he was inside the custody during the trial stage. And the plea is very probable. The other day I was citing a decision, he wanted the copy. If the defense plea is probable, it has to be accepted. Defense plea, if it is probable, that will be decided in view of the preponderance of probability and that is to be accepted. Here is a case, my lord, between the family, this is that, uncle, nephew, this is the fighting. Since 2001, the appeal is of 2001 and the occurrence of 93 perhaps, my lord. The occurrence 1/8/93.
What is the offense?
Offense is conviction 341, 324, 326.
341?
341, 324, 326.
And what is the maximum punishment?
No, sentencement.
No, yes, sentence.
Sentence is 6 months for 324 and 2 years and fine of 2,500 under section 326.
How much? 326?
326 2 years and 2,500 fine. Okay, any information is required.
And 341?
341 is 6 months.
And 323 for?
341 nothing. The only conviction 324 and 326.
IPC provision of offenders and.
Is up to 3 years and another is up to 10 years.
341 के चाहिए देखिए
What is the
I may be excused, my lord. In this case, we are not having the record. Requesting my lord senior to supply a copy.
Give him a copy.
Next Friday.
Next Friday.
A week's time, madam.
Yes, as requested on behalf of.
PO Act will not be applicable. Other day,
Huh?
not see verified.
What?
PO Act, it will not be applicable.
Why?
I will not see other day has seen the provisions. Only thing is, even if 3 years punishment is there, if he is 5 days also, distance are there, he shall be punished. That can be reduced and the case can be to the period undergone can be there.
3-4 days, too less.
Yes, that is because of family fight. Uncle, I will satisfy you.
Yes.
Item 14.
In 14 and 15, both the matters were not.
15 and there. Item number 15 and there. Is it? If you lordship we finish 14, I.
Item 14.
15 there.
Give him a copy.
15, my lord. It is a conviction under section 324 and 307.
Last occasion when I argued this matter, your worship had put me a question 320 in appeal. There was a conviction and sentence of 7 years under section 307 and no, 1 year under section 320. During pendency of the appeal, the matter was settled between the parties. So the appellate court had acquitted the petitioner from the charge under section 320. So for 307, he confirmed it. I have filed this revision. So again, in this honorable court in revision, my lord, the injured and the informant, they appeared and filed their compromise affidavit. Last occasion, your lordship has asked me question 307 is there, it's non-compoundable, and how it will be compromised. But I find out the judgment of the honorable apex court that this 2022-14 SEC page 531. Your lordship has done it.
This is impossible.
No, their lordship has done it. Even after conviction, there are same thing, same session judge. It was moved before the session judge, and session judge has refused to act upon the compromise. And they are
this judgment cannot.
No,
See,
no.
I have turned the page, which refers to the plenary power of the court under 142.
Or 142, but their lordship has also said regarding 482. And what in that case, my lord, what the High Court did, that even
Let me see. You are relying on which paragraph?
Your lordship, I am relying on paragraph. Your lordship, paragraph 11 and paragraph 11 of the judgment and paragraph 20. What their lordship has set up certain grounds on which this even non-comparable offense can be compromised. But here, what has happened in that High Court had did, High Court maintained the conviction, but set up the period already undergone. He was not satisfied, he approached the apex court. In my case, my lord, 30 years back, this occurrence has taken place. And this petitioner has also sustained certain injury during course of incident, my lord. And he was examined by the doctor. And he had undergone about 1 year in sentence as under trial and as a convict. So even if your lordship will say that this sentence will be set up, that will also suffice because he is not a man that he will, his conviction stigma will be there, it will affect him. So even that will meet the ends of justice. So I have also prepared a short note for your lordship's kind.
All right, give him. I'll see.
Yes. And how many days he has undergone. And even if your lordship
So what is the period?
Period he has undergone 1 year, about 1 year. I mentioned the petitioner was arrested on 6/2/94. He was released on bail on 9/3/94. Again, he was arrested on 6/9/6/94 and released on bail by the appellate court on 4/5/95.
All right, then period undergone.
Yes, that period can
give that period undergone.
I have given the note. So even that
pass out.
Yes, Melody in all the cases.
Only 15 or 14? Only 15.
15.
And 14?
14. 14.
Someone is appearing.
The petitioner is not appearing.
Hey.
2022. 2022. 14 page 5.
The order of this court by an order dated 18/9/2024. The Superintendent of Police Cuttack was directed to submit a report as to whether the petitioner of this case was alive or not. The matter was again taken up on 23/10/2024. So as there was no report available, a reminder was directed to be sent to the Superintendent of Police Cuttack to comply with the said order dated 18/9/2024. So it seems that the report, that no such report has been received from the Superintendent of Police Cuttack. Let a copy of this order be communicated to the Director General of Police. This matter on next week, when the Superintendent of Police Cuttack shall be required to be personally present in court.
Currently, in all cases, your lordship has appointed me. So I pray, my lord, my name may be indicated.
Name.